together with video evidence in support of his case. My Lord, this will become important in the end and will demonstrate or will show why certain charges failed, because not all charges were proved against the petitioner. He had excellent counsel prosecuting his case and defending him before Senate. My Lord, why then did Senate decline the prayer for adjournment? My Lord, this part of my submission is interconnected with the response that shall be submitted upon, my Lord, by my learned friend, Mr. Mukele. But, my Lord, we'll go to show that every opportunity was afforded to Paul Mwite Senior Counsel and the petitioner at the time to conclude the hearing. My Lord, on 17th October 2024, Senate concluded the hearing of the National Assembly's case at 1:15 p.m. The petitioner, the Deputy President then, Rigathi Gachagua, sat through all the proceedings and was all smiles in court. At 1:15, my Lord, the Speaker directed that upon resumption of Senate hearing at 2:30, the Senate would hear the Deputy President, Rigathi Gachagua, for 2 hours. The 2 hours that you've given us today, my Lord. My Lord, when the House convened at 2:30 p.m., and this is all in the affidavit, my Lord, of Jeremiah Nyegenye, sworn on 21st October 2024. When Senate resumed at 2:30, my Lords, counsel for the petitioner, Mr. Paul Mwite Senior Counsel, sought time to establish the whereabouts of his client, whom he had walked out of court at 1:15, my Lord. He walked him out, and then he suddenly disappeared into thin air. And when he came back, my Lord, at 2:30, he told Senate that his client was no longer visible. But, my Lord, to add to that, he then stated that he had made a phone call to his client, but had been told that his client had been taken ill. My Lord, what the Speaker did then was to suspend the proceedings of the Senate to 5 p.m. to allow counsel for the Deputy President to report the status of his client. My Lord, counsel was invited by the exercise of discretion of the Speaker and given 2.5 hours to report on the status of his client. And the report, my Lord, was simply for counsel to provide evidence as to where his client was. He had not told the Senate where his client had gone, whether he was in hospital or wherever he was, my Lord. My Lord, upon resumption at 5 p.m., the petitioner's counsel, Paul Mwite, stated that he had contacted doctors at current hospital who were attending to the petitioner. Suddenly, he had information as to the whereabouts of the petitioner. But then, my Lord, he had a caveat. He stated that he was not able to access or talk to him. And he sought an adjournment to Tuesday, the 22nd October 2024, to enable his client attend to his doctors. My Lord, it is that report that the court considered today and that Dr. Kikonyo testified to today, my lords. It is that report, my lord, that states that the Deputy President then would be discharged from Karen Hospital 31 days later. My lord, at this point, due to the nature of the proceedings, because this was a proceeding by the plenary, it was incumbent upon the Speaker to seek a motion to be tabled for Senate sitting as a quasi-judicial body to make a determination. It was not upon the Speaker to make that determination. And my lord, this is where the question of the independence of institutions and whether, my lord, the court can question whether Senate at that point exercised its discretion properly, or, my lord, whether it is open to court to consider, my lord, the finality of the proceedings in Senate as donated by Articles 145(7). My lord, that article then says that any motion, however, my lord, that brings me to this, apart from the other cases that I will refer to, 145(7) states that if at least 2/3 of all members of the Senate vote to uphold any impeachment charge, however hopeless, the President, or hearing Deputy President, ceases to hold office. My lord, Senate exercised its discretion against granting the adjournment on the 17th to Tuesday, 22nd October 2024. I said, my lord, this was a vote by Senate, sitting as 67 members. My lord, when Senate sits as a committee or as a quasi-judicial body, the standing order provides that they enjoy powers of the High Court. So, my lord, these were 67 judges, 67 judges, including the judge from Embu. 67 judges, my lord. In response to the request, my lord, the Speaker then ruled in line with the vote from Senate, rejecting the request for adjournment. My lord, that was after a supplementary order paper had been circulated in accordance with the rules and my lord, Rule 12 provides that once the motion commences, it must be executed to the end. My lord, what the prayer for adjournment sought by Paul Mwite Senior Counsel would have violated the provisions of Rule 12. Because then Senate would have then had to gazette a new date that was not consequential. Perhaps had the application provided that Senate seeks the following day, which would have been the 19th, Senate would have perhaps considered voting for the motion because it would have been, my lord, in consonance with the standing orders. My lord, once the motion was defeated, it was moved by Senator Aaron Cheriot, but failed, my lord. The Speaker then folded his hands he could not, as a presiding speaker of the impeachment motion, my Lord, make any decision other than what the majority of senators passed, which was that the impeachment proceed, my Lord. My Lord, at the time, and this instructed, my Lord, no evidence had been tabled before Senate on the medical status of the first petitioner. Senate, therefore, had no material before it to enable it exercise discretion in favor of the first petitioner. Number two, my lords, no testimony from Dr. Gekonyo or any other doctor in the panel of consultants or other assisting doctors had been provided to Senate. My Lord, the belated filing of an affidavit by Dr. Daniel Gekonyo, which was filed the other day, cannot amount to a sufficient compelling ground before Senate, because, my Lord, it not only comes too late in time, but comes after Senate had, sitting as plenary, concluded its work by having a vote denying the adjournment, my Lord. My Lord, what is the effect, and this is just something that is coming right on top of my head. What is the effect, my Lord, of the court finding that there were grounds that would have enabled Senate to allow an adjournment? My Lord, even if the court considers that the evidence provided today of several chest pains and other illness by the Deputy President at the time, my Lord, and that evidence is availed after 1.5 years of the sitting of Senate, my Lord, the court cannot correct that anomaly, as then the court would be acting not only retrospectively, but would then be faulting the act of Senate undertaken in good faith on the basis of material before it. But my Lord, let me also point out to one thing, that Mr. Paul Mwite, Senior Counsel, my pupil master here, and Mr. Ongoya, once they realized that they had no evidence of any sort, material, medical, or otherwise, including even call logs that he had made to the then Deputy President, they folded their hands and walked out. In fact, I remember Senior Counsel walking out and leaving Senate. Although it is impossible to bridge the evidentiary gap that made Senate to reject an adjournment. Although the Court of Appeal in Solo Kandie and James Kwambai Cheriot defined what constitutes an opportunity to be heard. As we submit, my Lord, that the petitioner was afforded every opportunity and was heard by Senate substantively for the Senate to have been able to arrive at a decision to impeach. My Lord, one, the opportunity to be heard, one is that an opportunity to be heard must be a full one to wit, where one voluntarily appears. Rigathi Gachagua appeared in the proceedings before Senate. My Lord, he had a chance to call witnesses. 3, my Lord, the opportunity must avail the witness the presentation of any relevant documents and must be fully heard. My Lord, in this instance, the petitioner presented and filed all documents before Senate. The court then concludes, my Lord, that the first is that the opportunity to be heard per se must be given. It was given, my Lord. The second is that the opportunity must be reasonable. It was reasonable. We had from the 9th to the 17th. 3, both these matters are justiciable, and it is for the court to decide whether an opportunity has to be given and whether that opportunity is reasonable. My Lord, that is why before you, and that is why we are submitting, my Lord, that in the exercise of its discretion, Senate not having been afforded an opportunity to interrogate the health status of the petitioner at the time of the hearing before Senate, my Lord, arrived at a correct finding by denying the adjournment sought for on the 17th, my Lord. My Lord, in Skogan and the city of Overland Park, which is a decision from the state of Kansas, the U.S. District Court had this to say about an opportunity to be heard, my Lord. And this is what the court stated, that the plaintiff had a full evidentiary hearing before the Civil Service Commission. This was a case, my Lord, where a challenge was made on a party who was challenging actions by the commission. My Lord, he then stated that he was represented by an attorney who had the opportunity to make an opening statement, like Ongoya did, but chose not to. And we examined the plaintiff and plaintiff's witnesses, cross-examined defendant's witnesses, presented documents and other evidence through witnesses. Paul Mwita Senior Counsel did all this, examined all the witnesses, and made a closing argument. The plaintiff also had the opportunity to testify on his own behalf. It is only this part that is in question, my Lord. And finally, my Lord, what else would a party have testified to in addition to the documents that they had filed in court? The plaintiff, my Lord, or petitioner in this case, has not told the court that there were other grounds other than the grounds that were set out in the pleadings filed that he had intended to testify to and that would have absolved him from the various charges, including the charges on shares. My Lord, what we had in court instead, my Lord, was a justification by Mr. Macharia and Mr. Ongoya that every government is founded on shares.
No, this government.
That this government is founded on shares. My Lord, that certain sections or parts of the country can be excluded from the sharing of government is a gross violation of Article 10 and Article 6 of the Constitution. And I think that is common ground, that you cannot govern by a minority or by tribes and exclude other tribes. My Lord, the testimony of counsel alone justifying some of the grounds, my Lord, would have been grounds to be presented before Senate and were duly presented and voted upon by Senate. I don't think there was anything else that counsel would have testified to before Senate to influence, or that would have influenced the outcome of the impeachment proceedings before Senate. My Lord, the Constitutional Court of South Africa, in economic freedom fighters and the Speaker of the National Assembly, and the jurisprudential landscape of South Africa is important because of the justiciable nature of some of the decisions of the houses, my Lord, but also some of the groundbreaking decisions of the Constitutional Court. That is why we refer to them. And because the South African Court, Constitutional Court, has paid homage and perhaps laid foundations for certain principles, including fair hearing and what the petitioner considers as best argument.